Okay, so welcome back to our third session of our conference. This session is on the state and Commonwealth environmental law reforms, which might sound a bit vague, but I'm sure that everyone's aware of the recent so-called reforms to our major pieces of state and Commonwealth environmental law, the Environmental Protection Act and the Environment Protection and Biodiversity Conservation Act. And the reviews of those acts which were undertaken. Obviously the EP Act is a hot topic with some of the reforms coming into force just a few days ago, and we've got some eminent speakers in WA to give you a rundown. So our first speaker is Robyn Glindemann. Robyn is a projects lawyer with specialist expertise in environmental and Aboriginal heritage law. She has 25 years' experience advising resource and energy companies, banks and government agencies. Robyn became a principal of Lantegy Legal in 2017, and in 2018 Robyn was appointed by the WA Department of Premier and Cabinet as a member of the independent panel reviewing the strategic environmental assessment of the Perth and Peel regions. Robyn is chair of the Australian Environment and Planning Law Group at the Law Council of Australia and chair of the Law Council's Climate Change Working Group. With her Law Council hat on, Robyn was engaged by the EPBC Act Working Group, governed by Professor Graham Samuel, AC, following the release of Professor Samuel's interim review report on the EPBC Act. So she has very specialist expertise to share with us today. Also, her connections to NELA are well known. She's a former president and current and ongoing friend of the National Environmental Law Association of Australia. Robyn is a regular guest lecturer on environment, climate change and corporate social responsibility issues at the Centre of Mining, Energy and Natural Resources Law at the University of Western Australia. Robyn is also a consulting editor for the Australian Environment Review and LexisNexis Butterworth's publication. Robyn has been named as a leading individual in climate change planning and environment, natural resources law and native title law in the current edition of the Best Lawyers in Australia, and a leading Perth planning and environment lawyer in Doyle's Guide. Robyn's presentation is entitled The Samuel Review of the EPBC Act, Status and Implementation of Recommendations. So I'll introduce Robyn. Can you all help?
There we go. Okay. The subtitle of my presentation is The Non-Reforms. I'm going to put my cranky pants on this afternoon and hope that Lee and Andrew are going to be far more uplifting. So I am speaking today with my Law Council hat on. The Law Council was involved in the Samuel, as a whole lot of other organisations were in the Samuel Review, but we did participate in the work that Professor Samuel did in between the interim report being released and the final report being released, which is actually very important to understand, and which is why I'm so angry about the current state of play at the federal level. So there are three areas of reform. Graham's report, of course, is a lot bigger. I printed it out. I'm a dinosaur. I need to read it in hard copy. But the government's only focused on three bits of it. They've done exactly what Graham Samuel said not to do, which is cherry pick. But I'm going to talk about three areas of reform because these are the only bits that have actually got up. So I'll talk about the approval bilateral agreements, which for those of you who were in practice in 2014 will realise that these are exactly the same as Tony Abbott's one-stop shop reform. I'll talk about national environmental standards, or standard, which is the centrepiece of the reform package that Professor Samuel put forward. And then I'll talk about the Environment Assurance Commissioner, which was one component that Professor Samuel put forward as a way of restoring trust in the system, which is a very big problem. They kind of got there, but not quite. So very quickly for those who are in a COVID cave, the Samuel Review, this is the second 10-year review of the EPBC Act. The first was chaired by Alan Hawke. Very few of those changes were actually implemented, so we're now at 20 years with no substantial reform to this cornerstone piece of legislation. Professor Samuel released his interim report in June 2020, and it had 3 headline items in it. One was the removal of regulatory duplication and support for the development of approval bilateral agreements. Not a new concept. Alan Hawke said the same thing. State governments love it. Federal governments love it. Graham, with his regulatory hat on as previous chair of the Trade Practices Commission and the ACCC, understands regulation and complex regulation. So actually he was a very good pick for the review because he understands regulation and public trust in a regulatory system. The second headline item was that the approval bilateral process should be underpinned by new national environmental standards, and this is really the centrepiece of Graham's reform. And as a reform concept, has a lot of potential in other areas, including Aboriginal heritage, but I'm not going to go into that space for the after tea speakers. And then the third component was a strong, independent cop on the beat to monitor compliance, enforcement and assurance for the EPBC Act. Now, at the time the interim report was released, Susan Ley, the Environment Minister, said, yeah, these sound really good. There was a couple of press releases, some bits in the article, and apparently National Cabinet at the end of July said, we will endorse a move to single touch approvals underpinned by national environmental standards as an immediate priority. So this was National Cabinet, when they weren't talking about COVID last year, they managed to get that little pearl out. So that was good. And then the final report from Professor Samuel. So they agreed, now keep in mind the dates here, they agreed to all of this in July, but the final report, which is substantially different to the interim report, was released in October. So the first thing, approval bilateral agreements. Did that move? There we go. Oh, how do I go back? Oh, there we go. Doesn't like that. There we go. Yes, okay. So, in the interim report, Graham Samuel said, a key criticism of the Act is that it duplicates frameworks. You've got the EPBC Act and the state frameworks. And, not surprisingly, the review at the interim stage said, yeah, we agree with that. So, Chapter 4 of the interim report focused on that regulatory efficiency. And they said, we really do need to develop approvals bilateral agreements. The concept of bilaterals is already in the EPBC Act, both assessment and approval bilaterals. And if you need some explanation about that, I'm happy to do that. It's not a new concept, as I said, and these were, in Professor Samuel's mind, the key condition for what he called devolution of federal power down to the states and the territory governments was compliance with national environmental standards. So for him, the national environmental standards were absolutely key to implementation of approvals bilaterals and removal of regulatory duplication if we were going to actually do something about improving the environment, as opposed to just maintaining the status quo, which numerous reports have said is not working. And then the other component of devolution for Professor Samuel was sound accreditation based on quality assurance, compliance, escalation to the Commonwealth Minister, so a Commonwealth step-in capability for approvals and regular review. So what do we get? Well, we got a 2014 piece of legislation with a new date on it, and that was pretty much it. There are a couple of minor changes. This bill is a very technical bill. It was there because when we had the first crack at approvals bilaterals in 2014, the Commonwealth realised that there are a number of elements of the EPBC Act as drafted that didn't work in terms of implementation of approvals bilateral. So they wanted to fix that to make sure that when they actually did these approvals bilateral agreements, and they got drafts up with all of the states and territories 6 years ago, that they would work. So they rebadged it, put out a new set of explanatory memorandums, and this was all done before the final report was released. So we're still in interim report phase. And surprisingly, it stalled. It was rammed through the lower house. You may remember there was a whole lot of press at the time about how government shut down debate, went straight into the Senate. And so, I'm no politician, probably never will be with my black sense of humour, but from a parliamentary process kind of view, it didn't work. It was a really bad look. And so once you've lost that, it's very hard to get it back. So they shoved it in, it's stuck, going nowhere. Next, doesn't like it when I move it up there. Did it again. The next component of Graham's reform are national environmental standards. So in the interim report, he had a set of prototypes. They were very, very basic, and they were there just to sort of try and explain what Graham was trying to do. After the interim report was released, Graham convened a consultative group which met over a couple of months. It was a pretty rushed process, but you name the peak body, it was in this group. It was the Law Council, it was the EDO, the Minerals Council, APIA, Farmers Federation, scientists, Wentworth Group, academics, Indigenous representatives. It was a very large group of peak body people. And the idea was we were going to workshop some key elements from the interim report, but that very quickly devolved down to what are the national environmental standards going to look like? What should they cover? What's the framework that we need? And a lot of effort went into those discussions, and there was, I've got to say, a lot of agreement about what national environmental standards should look like. This consultative group didn't draft those standards. Graham convened a separate group of technical experts to draft those standards based on the input from the consultative group. Those national environmental standards then appeared in the final report. So they're very, very detailed, and they cover these things. So it covers each individual MNES, Commonwealth actions. Now, it's not just technical standards he's talking about. We made it very clear that we needed to have process standards, standards around consultation, standards around Indigenous engagement, which was front up in Graham's reports. Focus on data. Can't make good decisions with crap data. How do we do that? How do we improve that? And all of those sorts of things. So the ones that are starred there are the ones that are actually in the final report. Note that he's already drafted one on Indigenous engagement. He's also drafted one on compliance. So it was very important when we're talking about national environmental standards in the context of devolution of Commonwealth power down to states, that we have a consistent set of standards, not just about how we protect matters of national environmental significance, but what's the decision-making process, because this is about restoring trust in the system and making sure that state and territory governments can actually uphold what is ultimately a Commonwealth obligation. So that was that. Graham was very clear, please don't cherry pick. This has to be taken as an entire package, and he put out the plan. They had to be legally enforceable. He said all decisions made under the EPBC Act, whether it's made under a devolved system or made by the Commonwealth, need to be consistent with national environmental standards, everything. This is how we get there. Accreditation of state systems had to be to these standards, not negotiable. And you'd only depart from a national environmental standard in a particular way and in particular circumstances. What did we get? Well, we didn't get a standard, we got this bill, which only talked about protecting MNES in a holistic fashion. So the bill was introduced in February 2021, final report October 2020, first bill, this bill in February 2021. It was referred to the Senate Environment Committee, which reported in June 2021, and it was also considered by the Senate Standing Committee for the Scrutiny of Bills. What the bill raised were some very serious issues about parliamentary oversight. when this bill was introduced, there was no national environmental standard attached to it. It was a bill to implement national environmental standards, but what's Parliament approving? Doesn't know, because it's not there. So there was a really serious issue about parliamentary process. National environmental standards, not a disallowable instrument, which means it just goes through. There's no parliamentary oversight. There's no ability to say no. So this was raising some serious parliamentary process issues. There were huge issues in the bill itself about decisions had to be not inconsistent with national environmental standards. I don't know what not inconsistent means, but it seems to be broader than being consistent. So there are issues about how these standards, whatever they were going to be at this particular point in time, about what they would actually look like and how you would enforce them. And then how are they going to be incorporated into approval bilateral agreements when we haven't even seen the national standard, and then what happens if standards change, all sorts of things. The solution to the parliamentary scrutiny was, well, we'll whack a sunset clause in. So at the moment, the initial national environmental standard, the singular, will only last for 2 years and then it will fall away unless it's replaced by a full suite of national environmental standards. So that was that. And we got, after this bill was introduced, the National Environmental Standard Matters of National Environmental Significance thing, because it doesn't have like regulation or rule or anything after, it's just 2021. So this is, it looks similar to Graham's national overarching standard for MNES, but there are some key differences. It only deals with a standard for all matters of national environmental significance. It doesn't go down into the individual MNES. This does not deal with any of the process standards that Graham Samuel had drafted. And it purports to be a summation of the current process, because apparently that's what National Cabinet agreed. But they don't release minutes of National Cabinet, so we don't know. So I just wanted to compare very quickly the drafting. I know I'm running out of time here. I'm going as fast as I can. So the heading of Graham Samuel's overarching MNES standard firstly says that matters of national environmental significance are protected and enhanced, and decision-making actively contributes to improvements in their conservation and management. That's the environmental outcome. The environmental outcome under the government one, matters of national environmental significance are protected to support the sustainable long-term conservation of Australia's unique biodiversity and heritage and the important social, economic, cultural and environmental benefits it provides. It's not the same thing. The national standard in Graham's version is actions, decisions, plans and policies that relate to MNES must deal with certain things, must meet certain standards. The heading in the government response is bilateral agreements relevant to matters of national environmental significance must. This is about bilateral agreements. This is not really about lifting the standard. It does talk about other environmental assessment and approval decisions, so technically I think the government minister the Commonwealth might adhere to this standard, but it's not there. It's not there up front as it is in Graham Samuel's version. So suffice to say, I was not impressed because you do all of this work as a volunteer at the Law Council, and then I basically felt very, very snubbed because we did put in a lot of work and we got some good outcomes, and those outcomes haven't been recognised. That's my rant for the day. The third bit of Graham Samuel's reform was the Environment Assurance Commissioner. Standards aren't enough. You've got to have the strong independent cop on the beat. And that's a quote from the final report. It needed to be supported by, there's my typo for this presentation, well-resourced audit function within the department. It's got to be public, it's got to be transparent. It was separate, and in Graham's mind, separate to the Independent Office of Compliance and Enforcement that he had also proposed. they haven't done too badly on that one. So it's in this Standards and Assurance Bill. It's in Schedule 2 of the amendments to the Act. It's largely there to oversee approval bilateral agreements. That's its function. It does have an audit function, but that audit function is not as broad as what was proposed by Graham, and it has no powers to act on its audit findings or to compel action on the audit findings. It's basically a report writing thing. In Senate Estimates committees, there's no budget for this commissioner at this particular point. So, next steps, what's happening? Negotiations are stalled on the bills. Unless a crossbencher crosses over, I don't see them going anywhere. They are stuck in the Senate. There is work being done between Minister Lay's office and Ken Wyatt's office on Indigenous engagement. And if you read the department's Pathway to Reform, which is a 21-page glossy ad for the EPBC Act reform as the government sees it, they're working on having an Indigenous engagement national environmental standard in 2023. So there is some work going in the Indigenous engagement space to improve that, and whether we go to national environmental standards or not, we need it in the Act. It's got to happen as a matter of practice in the Act anyway. But what we don't know, and I'm sorry, but the reform document, pathway document that the government has released doesn't help me answer any of these questions, but I'm not sure about what else is happening in Samuel's report. There is a commitment to have better strategic planning, better bioregional plans, improving transparency. But it's kind of my sense is the tinkering around the edges that are easy to do, rather than the wholesale reform that Graham had specifically planned and plotted out, including a timetable in his final report, and it's all there for everyone to read. That's my rant for the afternoon. Happy to take questions or opposing views. Ha! I've beaten the audience into submission. Thanks, Lee.
Thanks, Robyn. That's going to be a hard act to follow. Can you just talk a little bit about what Graham Samuel said about the importance of focusing on environmental outcomes and outcomes-based conditions?
Oh, God. Well, basically, he said that's the bomb. If you look at the standard, and I'll go to his words, he talks about the environmental outcome, and if I have a look at for Ramsar wetlands, the outcome is the ecological character of each Ramsar wetland is maintained through the conservation management and wise use of the wetland, having regard to ESD, ecologically sustainable development. So he was very much talking about outcomes. Now, how do you get there? Well, you've got to adhere to this standard. So he framed every single standard in the final report with an outcome. That's it. And he was very conscious during consultations and in our discussions in the consultative group about what the outcomes were, and all of the scientists in that group were focusing on outcomes, because the reform that's in and the review that has to be undertaken, it's not just about improving regulatory reform, it's not just about improving the way government makes decisions. We actually need to improve the outcomes from those decisions, because there's been so many reports that have said we're not meeting our obligations, and our biodiversity is declining, and this is supposed to be the piece of legislation that stops it. And it's the Australian government that has these obligations. It's not the state governments, it's not the territory governments, it's the Prime Minister's signature on the treaties. So it cannot shirk that responsibility.
Do you think really the outcome of this review was simply ticking a box to say that it's 10 years and we had to do it?
In my heart of hearts, I want to say no. Look, Commonwealth government atrocious. The only reform we've had was to introduce a trigger that doesn't even apply here, and that was the result of politics. So it's extremely, extremely disappointing that there hasn't been more of a commitment at that federal level, politically, to what Graham has proposed. The models that he has proposed in his reform document, and as I said, the guy comes from complex public-facing regulatory roles, ACCC, Trade Practices Commission. He's no stranger to complex regulation, but he could see a way forward, and he's provided, which Alan Hawke didn't do, he's provided a way forward. But it's hard. And, you know, the states have signed up to these national environmental standards, but they signed up to something they didn't understand because they weren't released when they signed up to it, which raises a whole different question. So will it just be put on the shelf? God, I hope not. I'm hoping that with the pressure from the Committee for Northern Australia and the Juukan Gorge Review, because the kinds of concepts that Graham talks about in this report can be applied to Indigenous heritage reform. There are so many things that we need to do on a cooperative level, and the politics of the pandemic have made our federation slightly more fragile than it once was, and that's going to be really tricky, which is why I'm not optimistic about Samuel's report, which is really, the older I get, the greener I get, and I'm really upset that I have to get to that point. I'll end there.
All right, thanks very much for that, Robyn. Always good to hear the truth about what's going on. And so our next presentation comes from Lee McIntosh, who is the Deputy Chair of the Environmental Protection Authority. So Lee McIntosh joined the EPA in November 2020 as the Deputy Chair. She has more than 20 years' experience practising as an environmental lawyer and extensive experience in corporate, government and community sectors, having been active in several environmental law, policy and reform initiatives, lectured and tutored in environmental law and worked across all areas of environmental law assessment and approvals. She's also held roles on several government and community boards and provided advice on environmental approval and social licence issues associated with some of Western Australia's most significant projects. Ms McIntosh has a master's degree in environmental law from the University of Calgary in Canada and a Bachelor of Laws with first class honours and Bachelor of Science in Environmental Science from Murdoch University. Lee's presentation is on the EPA Act reforms and the EPA's response, the reforms of Part 4, of course. And obviously it's very pertinent given the very recent release of these. So please welcome Lee McIntosh.
Thanks for that introduction. You just reminded me I was a corporate lawyer a year ago. So I was just reflecting on what's changed since then. So I suppose one change is I drive to Joondalup to go to work now. The conversations in the bathroom at work, when I was a corporate lawyer, the conversations in the bathrooms were about what's the best teeth whitening dentist to go to on the terrace, and then now about what plants everyone's going to plant in their garden on the weekend if it's going to rain enough. One other change would be how much I use my legislation now. You'd imagine moving from a lawyer to a EPA position, you'd use it less, but every day it's very different using your legislation as advising a client to thinking, how can I use this legislation to get what I want for my client, to using the legislation to say, how can I use this to better protect the environment for the state? So it's certainly something that we take very seriously. And very seriously also we've taken our obligation to implement the EP Act amendments which came through at the end of last year. So how do I... Sorry, I didn't... That? The big one?
That one.
Oh, the big one.
The big one.
Okay. Thank you. So at the end of last year, Parliament passed what's been dubbed the most significant environmental reforms of the Environmental Protection Act in the last 20 years. The key theme of those, similar to what Robyn was speaking about with the EPBC Act reforms, a very clear theme was to reduce inefficient processing, so reduce duplication, but also very clearly to try and increase environmental protection as well. So an example of the reduction of inefficient processing would be that the EPA now has a formal ability to take other decision-making processes into account when it makes particular assessment decisions under the Act. That's something the EPA has done before in the past, but without having a formal statutory power. The idea of that formal statutory power is that that should drive efficiencies now. On the increased environmental protection side, the Act clearly now makes the EPA responsible to consider cumulative effects whenever it makes a decision. So knowing those two things were the key aims of the legislation, what the EPA did, the first thing we did in thinking of how to implement them, was to look at all the reform opportunities that we had up front. And we first tried to look in our own house, and that was by looking at what can we do with EPA reports, which is the place that most people would read that the EPA publishes. What can we do in the reports to actually increase environmental protection but also be more efficient? And so what we recognised and we've tried to start implementing is to really focus in those areas on significance of environmental issues rather than all of the other things that other decision-making authorities might do, and also to improve the transparency there. We're hoping by them what we can do is reduce appeals. I actually think appeals processes are good. You know, as a lawyer, I think the more oversight and the more different views you have, you tend to get a better system, but they're not a very efficient way of proceeding, and we certainly think that if we're more transparent about our thinking processes, then there'll be less need to appeal. I think the first speaker this morning talked about there being, you know, a reasonable basis or a reasonable thinking process being evident in any decision. Another reform that we identified was to try and make sure that the EPA's recommended conditions are focused on outcomes-based conditions rather than management. So my question to Robyn before was about what did Graham Samuels think about outcomes-based conditions and focusing on environmental outcomes, and she said he thought they were the bomb. That's certainly what we think as well. I think environmental management plans take a lot of time and resource, and really what they're about doing is minimising an impact, but not to the point where you can say, well, is minimising it, does that still get you to a point that you're happy with? What we actually want to do in environmental protection legislation is know what the outcome is for the environment of these things and then mandate that. We identified there was certainly some key parts in our procedures suite where we could streamline EIA processes, so ESDs or environmental scoping documents. Most people would only touch these for a particular project, but once you're on the EPA and you realise that they're pretty much the same for all projects, we thought, right, we can just make that pretty standard and make all environmental review documents follow that, and then just focus in on what are the key differences for each project. So we think we can save about up to about 3 months in most approval timelines through that, using that process. A key part of what we want to do is use our documents to provide more upfront guidance for EIA. That was a key theme that came through when we consulted on how we're implementing the project, the process things, was people that just want more guidance. Tell us how this works, tell us how this is going to do. There was a perception, not recently, but you know, early on, that the EPA is a bit of a black box. No one knows what to expect or how to do it. So we really wanted to provide upfront guidance there. And hand in that is as well having a consistent focus on core EIA principles. So wherever you touch and feel the EPA process, you're coming up against the same principles. So they would be significance. That's what we're interested in. The mitigation hierarchy. So what can you, which is really, you know, what can you do to avoid the impact in the first place? Like thinking about the greenhouse conversation this morning, lots of the focus is on accus and offsets. It's a lot easier, and the issues of them, it's a lot easier not to have the impact in the first place. So after you avoid, then you minimise, and then you offset or rehabilitate then. And the last thing that we thought we could do, and we have done this, I think, through the procedure suite changes, is to clarify the EIA roles. There's been a tendency, I think, because EIA is expected to go for a long time, a tendency for proponents just to put something in and start the process and then presume that it'll get fixed up through the EPA process. So often we get documents that the proponents are expecting the EPA to be in a better position to fix than the proponent themselves, including about defining the proposal. I'm quite amazed when I hear the officers in the EPA regularly being asked by proponents, what's our project? I'm like, well, how would we know? Surely that's the base part of information you should know. So we decided to sort of clarify the EIA roles and think that streamlining and also better environmental protection come from who's best placed to make this decision or to provide this information or to work this problem out, rather than the EPA being seen as sort of a project manager for proposals all over. So, having identified those reform areas, we went out for public consultation in April on, and these are just the 10 key principles that we consulted on. I won't go through these in much detail, but just so you know that we did have some. And there was actually the outcomes of the consultation were surprisingly consistent, and there was a lot of support for most of these. I think the key one to mention there is the Principle 8 there, which is other decision makers' ability to mitigate environmental impacts. That was really the only one where there was a real divergence in consultation outcome for. We had some, say on the proponent side, going, all right, then EPA, if you can consider other decision-making processes, you should basically get out of the way. We don't really need you anymore. You should just defer to those and delegate to those processes altogether. And on the other side, I suppose from the conservation sector going, you shouldn't be delegating or deferring responsibility, EPA. You're the peak environmental independent body, and you shouldn't be relying on those other regulators who are more, politically captured to do anything unless you're completely satisfied that they will be able to meet environmental objectives. But I won't say anything more about this, just to know they were the principles that we consulted on. And then these are the key EIA tools that we're now rolling out. So last Friday, the amendments to Part 4 came into force, and a new administrative procedures, a procedures manual and a suite of other documents were released. Tomorrow there'll be another tranche, I think about 6 or 7 other key documents will be online tomorrow, and that will then represent the sort of the changes to the EPA's procedure suite to conduct EIA to, as I said, hopefully achieve both increasing environmental protection and reducing inefficient processing. So at the core, very deliberately, of this hub, I've put environmental outcomes. That's really where the EPA is focused on all of the time, and what's the key driver for all of these decisions. And then the tools, which I've got around the outside, are how we're proposing to make sure that in increasing confidence in environmental outcomes, this is the tools that we're giving to try and achieve that, and to reduce inefficiency as well. So the top one there, as I've already alluded to, is providing more upfront guidance about things. It's a double-edged sword with guidance, and we'll have in some submissions, it was interesting in the public consultation, they would say we need more certainty about this, but you also need to be able to make sure you provide us flexibility. So I was like, I can't really do both at the same time. So what we've tried to do is provide as much upfront guidance as is practicable, but knowing that every project is different, and the EPA, I think we've got double the number of normal referrals at the moment, and they're not all the same type. There's so much going on in this state at the moment with sort of new types of development. You can't really say that there's any 2 projects that are alike. So the guidance has to be taken as guidance rather than a set in stone thing, because we then need to apply that in each circumstance. Moving around the hub there, proponent responsibility is something that we have introduced as a key tool, and that's really getting proponents responsible to define what their project is in the first place. So, for example, the old the old Schedule 1, which is where of ministerial statements, which is where the EPA would say, here's what your proposal is. That won't be occurring anymore under the new procedure suite. The proponent's proposal document, they're similar to most approvals procedures, in Australia and the world. If you want to do something, you tell it what it is. You don't ask the EPA to try and tell you what your project should be. Focus on significance, as I've said, that's a really key thing, and so really focusing on what the key environmental values are. Proportionality, making sure that we get good information about the key risks to the key values, and then resources can be used for that, rather than having lots of resource used on something that maybe wasn't a key matter. Decision-making authorities, as I've alluded to, they are now something we can formally take into account. We've released an interim guidance on the type of things that the EPA has to consider in considering other decision-making authorities' processes. And the key thing there is we need to understand whether that other decision-making process is actually going to lead to an environmental outcome that's consistent with the EPA's objectives. So we don't just need to know that this is a mine and there's a mining act. We need to know what about it, what are the impacts of that particular mine going to be, and can another decision-making process actually regulate that to a way that would satisfy the EPA about its objective. And then consistency is another key thing we're trying to do, again, by increasing the transparency of our decisions. That will both help us make more consistent decisions and mean that you'll know what to expect more when you come in to touch an EPA process. So just focusing in on each one of those in a little bit more detail, I wanted to touch mainly on environmental outcomes. And the reason that these are so important is because as a decision maker, it's hard when you are just presented with a pile like this of management plans to tell whether that's actually going to be an environmentally acceptable outcome, or to be able to figure out what does this project mean for the environment. So we don't want to be thinking anymore about can a proposal minimise its impacts. We actually want to know what are the environmental outcomes likely to be of that project. The reason for this is that we want to be able to then set or recommend to the Minister to set environmental outcomes-based conditions that then provide security for the environment, for the public, but also for the proponents so they know what to do. And so resources, scarce resources in proponents can be used to make sure that happens, and to adaptively manage to make that happen. I think it's particularly ironic that we have this principle of adaptive management in management plans that then take 2 years to get approved. It's like the opposite of adaptive management with them. And what we discovered quickly was that in trying to draft outcomes-based conditions, it's very difficult to do that unless there's been a focus the whole way through the EAA process on what the environmental outcomes actually are. So we don't want EAA to be talking about what are the residual impacts of a project anymore. We still need them to do that, but what we want the thinking to start developing is into what does that residual impact actually mean for the environment. And then we want the outcomes-based conditions as a result of that to be clear and measurable, and what does this mean for the environment? And then rather than having a whole stack of management plans, as I said, we'll want its assurance monitoring. So the bulk of any plans that are required will be about monitoring to provide assurance rather than managing that. And then that provides flexibility to manage to meet that outcome rather than us being prescriptive about that. And I think that's a lot more consistent with where Part 4 sits in the Environmental Protection Act itself anyway, because it's not Part 5, it's not regulatory nuts and bolts, it's the decision making earlier in that stage, and then the other decision making authorities are meant to do that nuts and bolts regulation. The upfront guidance, just to let you know what the guidance will be coming. I think most of this will be out tomorrow, and it's certainly already in the procedures manual as well. So for where there's any new or substantially changed processes, we're providing that guidance. So there's a new Section 38C in the Act, which allows referrals to be amended before the EPA decides to assess them or not. And there's now under Section 43A, which is the ability to make a change to your proposal during assessment. A basically a mini EIA was required in there, and those amendments couldn't be allowed unless there was no likelihood that there would be a significant impact. That test has been removed, so there's now, it's at the EPA's discretion what to approve under 43A, so we provided some guidance there. And the 45C test, so for project changes after a ministerial statement's been issued, that statutory test has changed now as well, and that test is really now, it's not a comparative test with what you're already doing. The test under 45C is the change a significant impact in its own right? So what we've tried to do for all of these is say, let's apply basically a consistent test of significance. So wherever you're touching and feeling or trying to the Act amendments and you're trying to change your project, what you're focusing in on is the question of, is it a significant impact on the environment or not? I think I've spoken about most of those other things already, but there we're trying to provide, as much as I said, upfront guidance about all of those things. Just to touch briefly on proponent responsibility, as I've already said, the EPA, there's not going to be Schedule 1s for proponent for ministerial statements anymore. A proponent will, their proposal is what they say it is, and then that leaves the EPA able to then set conditions on what that is. So that's just more of a standard, all approvals regimes around the world. You say what you want, and then someone says, yes, you can do it, but comply with these conditions. That's the stage we'll be moving to. We've also taken the opportunity to clarify that split proposals should be avoided. We're seeing more of these, particularly around with the EPA's greenhouse factor guideline saying there's a 100,000 tonne threshold for, basically above that, then the EPA would consider assessing. You wouldn't believe the number of projects that have got suddenly 98,992 emissions, we've just got an independent power provider who's just off-site, but they're not part of our project, or things like that. So what we've tried to be clear about is no more split proposals coming in, particularly to try and avoid greenhouse thresholds. We've also tried to make it clear that proponents, where the responsibility is for them, is not around complying with a management plan that may or may not deliver what the environmental outcome should be, but it is actually around what the environmental performance is of that. And so then that means monitoring management plans and the resources in proponents that can go into doing those assurance and monitoring. We've made it clear that environmental performance is relevant when you want post-approval decisions as well. So it's not the case that you just get your approval and then whenever you apply for a change, that's sort of in a vacuum of how you've actually environmentally performed in the meantime, that will be relevant then. And for really long-term projects, there might be a requirement now to do 5-yearly sort of check-up reports on actually how's the environmental performance of that project going. So did all the assumptions come true? Consistency and significance are things that we thought really are, essential that we provide. So the significance test, as I said, we've tried to make that the same for all of them. So it's not a different test that you don't need to come and see a lawyer for wherever you're, whenever you're coming to an EPA process. And also there'd be a consistent focus on those core things. Just to touch on a couple of them that I haven't already, assessment of offsets is something that we've identified as something that we'll be needing to focus on, because offsets should only be required for an impact that is significant. And so then if an offset's being proposed, then we need to have some security that that offset will actually achieve its environmental outcome as well. You can't just say, well, there's a significant impact over here, but don't worry, we'll offset it, without having some security or assessment of what that offset is actually going to provide as well. And then alternatives are something that we're strongly encouraging proponents to do, and that's sort of explain the site selection process from the start. That's often a key thing that takes a lot of time and energy for proponents to sort out in their community consultation if they haven't been clear about how their site selection went. And then also consider alternatives as you go through the assessment process is a very important thing for the EPA to be able to understand. Proportionality, not really any, great science to this, other than just to say, look, the higher the risk, the more information we need, and focus in on the key values. Focus on environmental outcomes, as I said, not management. Certainly proponents need to have their management structures, but that's not something the EPA needs to particularly know about. We've also tried to make it clear that the quality of information that we're provided with absolutely affects the timeframes. So inefficient processes absolutely shouldn't be there anymore, and the best way actually to get an efficient process is to give the good quality information up front. As I said, we've provided a new interim guidance on decision-making authorities, and really what that does is direct proponents and also other decision-making authorities to say, look, if the EPA is able to take them into account, what we need to understand is that process likely to achieve an EPA objective or not? We're also starting off getting agreements or MOUs with the other decision makers, but I've been a year there now and I have to say we haven't got one yet. No, Peter Tapsell's laughing at me, so we are working on them, but in the meantime the interim guidance will be there. And a key thing for me through this process as well is to be able to ensure that the EPA can sort of, we don't have to do all the work ourselves. If we can get other agencies and other people thinking about what the EPA objectives are, that sort of extends the EPA's influence without us having to go back to Treasury and ask for more money. And it also means that for proponents, if they're going to a different regulator, they're not having to meet a different standard or a different environmental outcome. There's a standard set of environmental objectives that they can work towards. Just finally, I wanted to talk to you about cumulative effects and what the EPA's approach to this is, because that was a key change in the Environmental Protection Act amendments. So the EPA is now required to consider cumulative effects when it makes decisions. And the way it's proposing to do this is by focusing in on cumulative impact assessment. So we've defined what cumulative impacts are. They're the successive or the incremental and also the interactive impacts of a particular project with the past, present and reasonably foreseeable future activities. It's not as hard as it sounds, because past activities are usually, if you do an environmental baseline, then that's taken into account what those past activities are. So there doesn't need to be an explicit assessment of that. Reasonably foreseeable activities, future activities, what we've defined these as anything that's sort of existing and planned to keep on going, because obviously that will have a cumulative impact, but also any third-party activities that are already in an approvals process when the EPA's got the final documents. So then the EPA needs to be able to consider those cumulative impacts to do a cumulative effects assessment. The EPA has got, as part of its strategic plan, we've got 5 pillars. The first pillar is to consider cumulative effects. So that's a project that's ongoing for us. So we've provided as much guidance as we sensibly can at the moment, but there will be more coming on that. And at the moment, the way that we're approaching what cumulative impacts assessment means for a particular project is to scope that out with proponents at the pre-referral stage or even at the environmental scoping document stage. And so, for example, you might have, there might be some things where you don't need to do a cumulative impact assessment because there might not be any other values that are being affected by cumulative things. So it'll be on a factor or value basis. And there might also be some projects for which you have a different regional boundary that's relevant for a particular cumulative impact. So just depending on what the value is being impacted on. Just finally, I wanted to leave you with the document suite, as I said, is being rolled out from last Friday. And there'll be another, most of the rest of the documents will be available tomorrow. We are doing a health check of how this has gone next year, and that will also align with our review of the Quinlan review, which was a review undertaken by the Solicitor General after the, what case was it? The Beeley Wetlands case? Yeah. So there was a big rewrite of the EPA's procedures suite. That's now been there for 5 years, so we need to review that, and that will include a health check of the reforms that we're doing as well. We really encourage anyone to give ongoing feedback. I've put the email address there. We're not expecting them to be perfect, and it's a hopeful reform process, and we'd really appreciate the feedback about that too. Thank you.
Are there any? We've got time for one question. Oh, good. We've got time for one quick question, and if you're not quick enough, then I'm going to jump in. Does anyone have one? Well, my question is about the sort of the split referrals and the cumulative impacts focus, and are we seeing there sort of the implications of the North Galilee Water Scheme decision in the federal court, you know, to do with that sort of splitting off of the coal seam gas project and the water part of it? Is that the sort of thing that the EPA is looking at in taking that cumulative approach, or is it just about looking at the science?
Well, it would be both, really. So for what we want to do is avoid projects being split up, because you need to be able to, there's a number of good policy reasons that you need to consider a project and all its elements. One of them is that we don't want to leave the minister in a decision-making position where she said yes to one thing and then she has to say yes to another, because that happened. And I suppose the leading case that I always go back to in this is the Pioneer Concrete case, which is there was a mine in Queensland and they got that approved, and then they went back 3 months later and said, "Oh, sauce, we forgot to get the road, which is going through through a national park." And so the court said, "No, you need to include all those bits together, so the public and the decision makers can be properly informed about the cumulative impacts, but also so the minister's not put in that decision." So that's the reason to have a whole of projects considered together, and then cumulative's like a step bigger than that, which says it's not just one project's impacts that might impact on the environmental outcomes or values, it's actually all of the things that affect the environment at the same time. Thanks.
Thanks, Lee. All right, thanks for that, Lee. Always good to get a very direct perspective on the new era of the EPA. Okay, so our next speaker is Andrew Mack. He's the Associate Director at Talis Consultants. He leads their environmental practice, having joined in early 2014. He has a wide range of expertise and a variety of experience accumulated over 25 years of industry involvement. He worked within state environmental protection agencies for over 8 years before becoming a consultant in 2003. He is a certified environmental practitioner and has qualifications in engineering, business and law. Andrew will be speaking to us on the Part 5 reforms to the EP Act and the practical opportunities and challenges with these. Please welcome Andrew.
Okay, the big red button. I'm going to talk a little bit more around, I guess, the broad principles around Part 5 of the Act and some of the changes that have occurred, not necessarily the changes to the legislation, but some of the changes that are going to affect Part 5 of the Act itself. Excellent, that's working. I'm going to give you some thoughts and views, which are, I guess, my own to some extent, but hopefully will stimulate a few questions at the end of the day. So, as you know, the Act is over 30 years old and it's been well picked through. I'm sure you all have a dog-eared copy sitting somewhere in your offices on a shelf, much like me. You probably all know it inside out. And if I'm honest, I quite like the EP Act. It feels familiar and comfortable. And I was chasing a bit of an analogy around, I guess, the Act itself when I was sort of thinking through this presentation. Anyone got like a pair of favourite jeans that they like to wear? You might think they look pretty good, they still fit pretty well. You might still think that you maybe look pretty good in them. And they're still working for you, and they're good and familiar and comfortable. but perhaps you know that they're starting to look a little bit average and should be perhaps updated to reflect maybe the rest of your wardrobe. This is, I guess, the best analogy I could come up with about the EP Act, having worked with it for sort of since the mid-90s. I guess there's been some previous amendments that were alluded to previously. There was separation and clarification of roles between the CEO and the chairman in 1993, introduction of procedures around planning and environmental assessment in 96, provisions regarding legal proceedings and penalties in 98, and then clearing provisions, etc. in 2003, and material and serious environmental harm, which Alex referred to earlier on today. And so I guess the current bill it reflects, as most people have said, the fairly serious change to the Act. And some of the amendments come through a number of reviews which have been undertaken since 2006. Interestingly enough, the reviews that I've sort of seen all sort of were reported in 2006, 2009, well actually 3 in 2009. So those recommendations are now 12 years old, and it's not clear whether any further reviews were, I guess, completed in implementing those changes. I've got up here, I guess, what the government's vision for the updates were, and you can see there streamlining processes and reducing regulatory burden and modernising and words to that effect. One-stop shop is something that we see quite a lot of. So there's a lot going on in that space, but I'm here to talk about what's happening in Part 5, and according to DWER, the changes are going to improve flexibility, simplify the process, provide more certainty both for what is regulated and for the scope of defences, target activities and emissions, and reduce unnecessarily regulatory burden. Changes cover a range of things, including NVCPs, native veg clearing permits and environmentally sensitive areas. I'm not going to touch on those particularly today, except to say that the old processes for ESAs they were declared by notice, whereas under the new bill they're going to be made under regulation. There's a voluntary referral to the CEO for clearing permits, greater evidentiary requirements for remotely sensed images, environmental protection covenants through condition of NVCP or ministerial statement. But more importantly and more interestingly to me at least is the Part 5 approvals side of things, which covers, I guess, the approvals themselves, how to secure and modify an approval, what the approval can actually cover, and then the enforcement of the approval. As you will no doubt realise, changes to the Act are one thing, but there's no guarantee of their success. So what I want to run through is a little bit about some of those changes, and we can then debate at the end of the day the outcome. So one of the key changes, no more works approvals. Prescribed activities will replace prescribed premises, and basically they're those activities that could cause pollution. So we're licensing the activity, not the premises, and that allows a licence to be granted to another person other than the occupier of the land or the land that the premises is on, based on operational control. It's a change in process from a focus on the premises that could cause an emission to an activity that could cause an impact. And it also allows for overlapping tenure and premises, which is a fairly significant change and an important one. The changes to the Act also cover controlled works, which are those defined here, and basically those works that require a licence. They cover construction, installation or alterations to buildings, structures and plant equipment, much like the old works approval approach that was in place. They are those works that have that generate or have the potential to generate significant environmental emissions. This is a good move from my perspective and provides a lot more versatility in this space. There is also the opportunity to opt in for licences. Again, looking towards some of the commentary earlier about defences that was made earlier today. You can ask for a licence even if you don't meet the threshold, and again, providing that security and defence for possible litigation. There are potential concerns coming in place in relation to what will be considered a prescribed activity. The department is looking to review its 89 current categories, but we're, as far as I'm aware, not sure what that review will entail. What is interesting to me in relation to this one instrument is what that instrument will look like. We've seen previously where we've had multiple iterations of licences, multiple amendments. What we're going to get here with the removal of works approvals is an instrument that is amended quite regularly, and in some instances you'll have multiple amendments going on at the same time. Will that constant amendment process become a problem for the department? We've seen that previously where they got overloaded with work. They tried to, issue just little snippets of instruments, I suppose, to cover the amendment that was just released. And that backfired, and we had loads and loads of, backlog in terms of licences trying to catch up. There was a piecemeal approach to licensing, and it became very hard to sort of clarify what was approved and what wasn't approved. So I guess there's some question there around the previous experience that the department has in that space, and how will the process within the DWER deal with these multiple iterations and multiple amendments of licences and condition sets over a period of time. One of the major changes in terms of how licences are managed, which I guess is not necessarily covered by the Act itself, are in relation to what licences are issued and for what activities. The DWR intends to, I guess, go through a tiered system, as you can see up here, for this approach, and I guess to some extent comes back to the principles of self-regulation to some extent, and being able to trust a proponent. The tiers include standard activity approvals for certain criteria. If they are met, I've got in here, in inverted commas here, a rubber stamp approach, much, I suppose, much like the registration approach that's currently in place. It'll require a statutory declaration and fees up front. There's the streamlined assessment, which covers low-risk projects and requires a self-assessment and a self-risk assessment being undertaken by the proponent. DWER will then validate that, including its own risk assessment, and approve using standard conditions. And then there's the detailed assessment, which is for, I guess, the more risky projects. It's a bit more business as usual as we sort of look at the current process for licensing at the moment. DWER is currently undertaking an internal review of the drafted standard activity approvals package, which is including, according to DWER, testing and trials within their organisation, within industry regulation. They're aiming to roll this out by May 2022, next year, to coincide with Part 5 Environment Online launch, or earlier where possible. And the rollout will include some updates to the guideline for environmental siting. And they'll be updated following proclamation of the Part 5 EP Act amendments to allow for mobile activities to occur. The trial categories you can see up here include screening of materials, material recovery facilities, asphalt manufacturing, and concrete batching manufacturing and cement product manufacturing facilities. There is a heavy reliance at the moment in terms of this process on EPA Guidance Statement 3, which, as you may recall, is about 18 years old, and technology certainly has moved on. So I would be hoping to see a change to, or an update to that guidance statement, or at least some DWER advice in relation to separation distances and buffers that reflects the current state of play with separation distances. The development of the Tier 2 streamlined assessment framework includes the establishment of pre-application tools, defined eligibility criteria and screening tools. There's going to be a self-assessment decision matrix and conditions library, and I think we've been down this path with conditions before, which will guide applicants through self-assessment processes and define the Tier 2 approval. And again, they're looking at testing and trialling with these categories as well as trials for categories 58 and 58A, so with additional categories and premises to be included as the framework develops. So some fairly significant changes there, which, if they do play out well, will, I guess, create some efficiencies within the system, hopefully. To implement these changes, there are obviously going to have to be some changes to the application process and associated guidelines that are going to be required, and certainly in light of some of the decisions that came out of the Forest and Forest decision that applies to mining proposals, where an application must be accompanied by certain things and must be in the form prescribed. If not, the CEO has no discretion within the statute, within the regulations or the legislation, sorry, to deal with that. The CEO must decline to deal with that application. So a very clear definition of what an application should look like and should contain needs to be developed, and the DWEO is already starting to work through this process with the SAAs, the Standard Activity Approvals process, being the first cab off the rank, and there's a bit of a draft application form that they're playing with at the moment up there. And you can expect further amendments and requirements and structure to follow with all other applications as well. Applications will also be changing in a number of other ways. There'll be the consideration of the related activities in the new Act, and this is a question that has not yet been resolved. I guess the question here is how closely related does an activity under Part 4 need to be before it precludes approval under Part 5. There's no detail in relation to that yet, but I'm assuming common sense will prevail in that respect. Maybe that's a question for Lee later on. The publication of applications is something also that brings some consistency to the process, where DWER publishes the application documentation that it's received. It means that there's also some consistency with the proposed removal of works approvals and these aspects being progressed through licence amendments. So you can see now every licence amendment will go through a publication process. Some other commentary here in relation to the CEO's regard for any planning approvals or instruments, or interestingly, any other matter that is considered relevant. And I feel this could work both ways for a development. It could allow for some recognition that some matters are better considered through other legislation, be it mining, be it planning, but the, I guess, rather open slather approach of any other matters the CEO considers relevant does leave, I guess, some questions and leave me worried somewhat. The question of relevance does not appear to be open to discussion here, and the relevance question could be utilised, I suppose, for good as well as evil in a decision-making process. Some food for thought there, and some clarity hopefully will come through further guidance and regulation. Amendments to licences. Obviously, if we're removing works approvals, amendments, changes to licences and construction will now need to go through an amendment process, and that's being updated to require the publication of application details, including supporting documentation. And under the existing legislation, before a licence amendment is made, notice must be given to the licence holder. The new bill introduces two new exemptions to that, where the licence amendment was made at the application of the licence holder, or to give effect to a decision of the minister, or on appeal. Appeal rights for amendments application which is refused, so that's a new change as well. But appeals continue to be heard through the appeals convener and minister, rather than an independent tribunal or something similar, which is something I was discussing outside earlier. Changes in Part 5 to offences and defences. Maybe nothing major, but worth noting nonetheless. There's an expansion of persons who can be liable for non-compliance. So this is applicable to persons other than the approval holder. Very much broader and potentially includes contractors, consultants, employees, and the like. So there is a greater exposure also for licence holders for the actions of others. There is a new defence included, which is a lack of knowledge defence, but it's obviously not a very good one to use and wheel out in court. There is some expansion of other defences in relation to unauthorised clearing and the use of due diligence to condition contraventions. Alex spoke earlier. Alex Gardner spoke earlier about the issue I'm about to speak to now, which is the restriction and authorisation defence. Previously, or now until the bill goes through, you had a licence and that provided a defence for your emissions from the premises. The proposed changes, the defence only applies for those emissions considered and specified within the licence. So that does leave a question open as to how far you want to go with your material emissions. They should all be considered and captured within the licence in order for that defence to be available to you. And I guess there's the question of whether greenhouse gas emissions are considered pollution or do trigger off the question of environmental harm. That needs to be fully explored and considered by proponents and regulators alike. The Act now has a head power for the accreditation of practitioners, which establishing or recognising a scheme or system for the accreditation of persons as environmental practitioners for the purposes related to this Act. So it's the entire Act, not just Part 4, not just Part 5, but the entire Act. It's voluntary at this stage and likely to follow something along the lines of the Environment Institute of Australia and New Zealand's Certified Environmental Practitioner Scheme, but the details on this are yet to be provided. So it's a bit of a watch this space. One of the questions I have is, will the DWER have the same level of rigour turned to it? Should government hold itself to the same standards? Should its staff perhaps have some level of accreditation as well? And assuming that there is that level of accreditation from proponents, will there be an expectation of fewer queries and questions through the process? Noting that I guess the intention to change the Act was to promote best practice environmental protection and sustainable development through effective regulation. I would expect that what's good for the goose is good for the gander in relation to that into that situation there. There are some other changes that are going on. The DWER has a licence review framework out for comment at the moment. This covers the processes where DWER initiates a formal review of a licence, typically based on a number of issues, either through complaints or breaches that have occurred, breaches of conditions. It doesn't replace necessarily the formal or the typical amendment process which can also be followed, but formalises the process that DWER can utilise to actually review a full licence. I guess this is an important step in terms of understanding the process that we're all working to. They intend to release a guideline around the triggers for review, scoping the review itself, what's in and what's out of the review, determining the information that's required within the review, and then the outcomes of the process. And they'll be then dealing with the procedure, the process that they want to go through, and the target timeframes they intend to use to I guess, deliver the review, and then the scoping process, the assessment and the outcomes, with publication of the scope of review and timing and updates provided on the website, hopefully to provide better transparency. Other changes, you would have all heard about Environment Online. I guess, again, this is a one-stop approach, stop-shop approach to approvals. Quite what it's going to look like is, in my view, still to be revealed, but it's understood that it'll make the approvals process simpler and more transparent. The Part 4 build is currently occurring and happening at the moment, and the Part 5 build will occur shortly after this, with a May 2022 target date set in place by DWER. They're also going through this, as part of this process, they're reviewing the prescribed activities and also the fees that are associated with all of that, particularly given that the works approvals will be removed and we'll be going down a licence amendment route for any construction, etc., that's going ahead. So there's a consultation process that's going on at the moment. I guess the question here is how much simpler will Environment Online make things, and whether it will result in actual improvements in efficiencies and timelines. So, some concerns and commentary. Realistically, this is all driven through regulation, and until we see the regulations, we're pretty much left to guesswork as to what's going to be coming through the process. I would suggest that there is going to have to be a very extensive consultation process with respect to the regulations. Hopefully something a little bit longer than the 5-week consultation process for the Part 4 cost recovery. Management of approvals for specific works and operations with the loss of works approvals is going to be of interest. I think in theory it will work, but the practice will be obviously the test, particularly when we see how big these licences get and how many, the multiple amendments we see coming through in terms of conditions. Obviously, the guidelines will need updating. The question around related issues, what scope and extent could be considered related in terms of the interaction between Part 4 assessments and a Part 5 approval. Emissions need to be specified for a licence to provide a defence. We've talked a bit about that today. There's a broader scope of persons subject to enforcement actions for non-compliances. So for anyone who is actually practising in this space, you can be held or can be held to enforcement action for a breach of a licence on a premises that you're dealing with. The fee reviews, there's no works approvals, and there's going to be a revision of 89 categories, and obviously this in itself has potential concern in relation to what will be considered a prescribed activity. And then there's obviously the tiered approach and reliance on EPA guidance statement for the current or the assessment of standard approvals, standard activity approvals. So the changes to Part 5, in my view, have the potential to become game changers in terms of how approvals processes work. Regulations, as I said, are going to be key, and the significance of these should not be lost. The changes to licensing and Environment Online have the potential to streamline and improve approvals, but I think they also have the potential to complicate things if not done well. And for my mind, resourcing of the department is critical. You can have the sexiest, nicest, shiniest bit of legislation or machinery, the nuts and bolts, as Lee mentioned earlier. That can all be changed, but you need good people to drive it. And at the moment, we're seeing good people being dragged elsewhere from the department, either into industry, either into Environment Online for that build, or elsewhere. So more resourcing, more training, opportunities for departmental staff to get out for site visits, either through preferably through industry groups like the Chamber of Minerals and Energy, and potentially certification for their competency. There's a question here as to whether all of this, all the changes, in my mind, is just window dressing. I think without resources and training, there are potentially more issues to the changes than they necessarily address. So, in conclusion, in theory, the changes will provide quicker and more efficient processes, potentially remove some of the constraints to approval that have dogged the system in years, and there are plenty of examples where I think this could work. Provide better transparency in the process and a more equitable approach to approvals. and lead to improvements in approvals and better environmental outcomes, in theory. I agree with all of this in theory, but we're not going to see how all of this plays out until we see a few things. I've come up with 3 R's, not reading, writing, arithmetic for the department, but regulations, resourcing and retention. Nothing here really plays out until the regulations are released. I think, as I said, we're all going to be a little bit in the dark until we see those regulations, and I would expect a long and fairly detailed comment period around that. My ongoing concerns, and this is something that I've had for many, many years around resourcing within the department, training of staff and their retention will also be a big factor in whether these changes actually work the way that they are intended. I think we've all seen cycles of regulation before, prescriptive licences, command and control, self-regulation, nil condition licences, template or library conditions and the like. I just hope that this current process doesn't become another example of something that promises a lot but delivers little. So, coming to the end, you might remember my really bad genes analogy at the start of the presentation. The regulations, resources and retention of skills within the department are all going to be factors in you wearing a new pair of jeans. If they don't stack up, then perhaps you're going to prefer to end up wearing your current, well-loved, comfortable pair to the bitter end. Thank you.
Thanks for that, Andrew. We have time for one quick question, if
One quick question.
there's any in the room.
Oh, it's got to be Belinda.
One thing I've noticed you is linked to training, but it's a bit different. I think the other fundamental issue to success in this space is a culture change. Would you agree that the success of the implementation of these new processes and theoretically better processes for the community, the environment and industry, hopefully, will be determined on the culture of the department and the staff within it, and they're being brought along on this journey?
I don't disagree with that. I think the culture within the department has gone through a significant change over the last few years. Certainly since, I guess, Mike Rowe came on board, there's been a significant change and a significant improvement in the culture, the ethic, the ethos within the department, and that covers the EPA as well, I guess, through the changes to the chair, the changes to the board and the staff in there. So I don't disagree with you that culture is critical. And I think the culture within the department also has a flow-on effect to the culture or the experience that proponents and the community have as well, and other stakeholders have as well in dealing with the department and the regulation there. So it has to start within the department. Everyone's got to be on board with what occurs there, because if that doesn't occur, then proponents are not going to play nicely. The community and the stakeholders are not going to play nicely either.
Thanks, Andrew. All right, thanks very much to our speakers in session 3. You've helped us prepare for the changes that are happening and gotten us fired up for those that aren't happening quick enough.